Well, good morning, everyone, and welcome to another in the Issachar Foundation Jamaica's public lecture series. My name is Philippa Davies, a member of the Issachar Foundation Jamaica, and I am opening our morning session and will shortly hand over to our moderator for this morning's panel presentation, Helene Coley-Nicholson. Welcome wherever you are located, whether in Jamaica, the wider Caribbean, or other parts of the world. A special welcome to this morning's panel presentation on Saving the Savings Law, Privy Council, or CCJ. If this is your first Issachar Foundation Jamaica lecture, special welcome. To let you know that this lecture series provides a discussion forum to explore public policy issues and social trends within the context of the Judeo-Christian worldview, which the foundation unabashedly affirms as the soundest foundation for nation building and human flourishing for everyone. We take our inspiration from 1 Chronicles, chapter 12, verse 32, which says, "The men of Issachar understood the times and knew what Israel should do." At this moment, I'm going to invite the chairman of the Issachar Foundation Jamaica, Dr. Wayne West, to make opening remarks. Dr. West?
Well, I want to welcome everyone to our lecture series. Our intention is to give people information so that they would know what to do. And we think this is a particularly important one because the final court of appeal determines a lot in our societies. And this doesn't only apply for Jamaica, but also for the rest of the Caribbean. So we welcome you and hope that you would have a useful time this morning. Should I open in prayer, Ms. Philippa?
Yes, please do.
Lord, we thank you. We thank you for your goodness. God is good. You look at this earth that we have, the fruit trees, everything, the air we breathe, the water we drink. God is good. He sustains us. But he doesn't only sustain us, Lord. You don't only sustain us with the material. You sustain us with spiritual things. You've given us your word. You've told us what we ought to do. You've given us a path for us to travel. And we thank you that we in the Issachar Foundation can be a part of that, that we are able to help people to understand where they are and where they ought to go. So we pray for this morning's proceedings, and we ask that you would bless it. It will be fruitful, and it will be for your honor and for your glory. In Jesus' name we pray. Amen and amen.
Thank you very much, Chairman. Now, the Issachar Foundation Jamaica has hosted public lectures since August 2010. Before COVID-19, we met face-to-face, but since June 2020, we migrated online, and this is our 17th virtual lecture. Some of the previous topics were moral inputs, mortal outcomes, bridging the gap between values and crime, uncovering the hidden facts about NIDS, the National ID System, life with COVID, health, law, and liberty, weeding the family tree, the generational impact of ganja on the brain, keep us free from evil powers, an expose on the new ACP-EU agreement, combating state corruption 101, two is better than too many is leaving Jamaica with too few, human rights and justice for the unborn. These are some of our previous lectures. And if you'd like to view them, I invite you to visit the Issachar Foundation Jamaica YouTube channel, where you can view the previous lectures at your leisure. And even though they were previous, these topics are still very much current and relevant to us today. Please also subscribe and like the channel. And if you are not on our mailing list, but you would like to receive notification of future lectures, please post in the chat your email address. After our panel presentation, there will be an opportunity for questions and answers. We will only take written questions, however. You are to post the questions in the chat, and they will go to the hosts of this morning's session. Your mics will be muted throughout the presentation. And now I'm going to hand over to our moderator for this morning's panel presentation, And she is Helene Coley-Nicholson, an attorney at law and the president of the Lawyers Christian Fellowship Jamaica. Helene, over to you.
Thank you very much, Philippa. Good morning to Issachar. Good morning to our guests online. Thank you so much for being here this morning. This is the day that the Lord wanted you to participate in this forum. Now, for the last 10 years, since 2015, a legal battle has been raging in our courts over the Savings Law Clause in Jamaica's Charter of Rights. The case has come to be known as the Buggery Law case, Maurice Tomlinson versus the Attorney General of Jamaica. As with a similar constitutional challenge in 2013, several church umbrella groups, the Jamaica Coalition for a Healthy Society, the Lawyers Christian Fellowship, and Hear the Children's Cry, joined the court battle as interested parties. These groups have been pushing back against a well-funded litigation tide of international proportions that seems headed for the Privy Council in the UK. Continuing the use of metaphors, there's a wind blowing in favor of the Caribbean Court of Justice to be Jamaica's final court of appeal in place of the Privy Council. What do legal scholars think of the two forums? And what is the likely outcome for the next constitutional challenge if and when Jamaica accedes to the CCJ? In October 2023, the full court in Jamaica ruled that the constitutionality of sections of the Offences Against the Person Act cannot be inquired into in light of the Savings Law Clause in Section 1312 of the Charter of Rights, and they dismissed Tomlinson's claim. And subsequently, as most of us know, there was an appeal. The question, is the Savings Law worth saving? And what of judicial attitudes towards the law and our culture? Well, this morning we'll hear from two eminent attorneys who have been on the front line of the battle, Ms. Shirley Richards and Ms. Jamila Thomas. They'll speak with us on the subject, Saving the Savings Law, CCJ or Privy Council. Shirley Richards is a Christian, a mother, and a grandmother. She was called to the bar in 1982 and is senior partner in the law firm Richards, Edwards, Theoc and Associates. She is a founding member of the Lawyers Christian Fellowship and a director of the Jamaica Coalition for a Healthy Society, for which she acts as lead counsel. Jamila Thomas was called to the bar in 2004 and is a partner in the law firm Lammy Thomas and Company, a firm started by her mother, Lilith Lammy Thomas, a founding member of the Lawyers Christian Fellowship. Jamila has made submissions before the Joint Select Committees of Parliament. She's a vice president of the LCF and is instructing counsel in the Tomlinson case. She loves the Lord, and her mantra is, the just shall live by faith. Let's tune our ears to what they have to say. We will first of all hear from Shirley and then Jamila, after which we'll be happy to answer any questions that you may have. Over to you, Mrs. Richards.
Thank you, Mrs. Coley-Nicholson, and good morning to everybody. So, thank you for tuning in. I'm dealing with the topic, the approach of the CCJ to the Savings Law Clause. So what is the Savings Law? So in the Jamaican context where we are speaking of constitutional matters, the Savings Law consists of various clauses within the Charter of Rights, and you will know that this is Chapter 3 of the Jamaican Constitution. And these savings law clauses preserve the validity of certain laws from the effects of the provisions of the Charter of Rights, thus providing immunity from judicial challenge. An example, so Section 1312, Helene mentioned that a while ago, nothing contained in or done under the authority of any law in force immediately before the commencement of the Charter of Fundamental Rights and Freedoms relating to A, sexual offenses, B, obscene publications, or C, Offenses regarding the life of the unborn shall be held to be inconsistent with or in contravention of the provisions of this chapter. It was this clause which forced the judges to dismiss Mr. Tomlinson's action at the level of the Supreme Court. Other examples, the death penalty is saved, Section 13.8. Also, the definition of marriage. Now, although that was not in law, common law, marriage has now been defined and saved within the Charter of Rights. So I'm saying as citizens, we need to be very concerned about the approach of any final court to the interpretation and application of savings law clauses, as these clauses are critical. So what's the approach of the CCJ? I'll be examining 2 cases decided by the said court. Basically, what we want to do is to ascertain the approach to the matter of these clauses. These cases are Navarre versus R and Severin versus R, heard together, both on appeal from Barbados. Then there's a McEwen against the Attorney General of Guyana case, commonly referred to as the cross-dressing case. Now, as we proceed, we need to be conscious of the matter of judicial precedence. So basically, decisions and reasonings in one case will affect subsequent cases with similar facts and issues. One can sometimes tell the outcome of a matter before the court if one is familiar with decided cases which are on point. So as we go through these cases, listen out for the reasonings and decisions which could be utilized to attack our savings law clauses. So what were the cases all about? Navarre and Severin case. This case was heard by the CCJ in 2018. It was an appeal from Barbados. The case concerned the mandatory nature of the death penalty as stated in Section 2 of the Offences Against the Person Act, Barbados. This section reads as follows: any person convicted of murder shall be sentenced to and suffer death. Issues arising in this case, the Court of Appeal had ruled that while the mandatory death penalty is inhuman and degrading punishment within the meaning of the Constitution, it is provided for in a law that predated the Constitution and is therefore afforded immunity from judicial challenge. So in this case, the Court of Appeal, the Barbadian Court of Appeal, had held that the law was saved by the particular savings law clause within the Constitution, and thus that law was afforded immunity from judicial challenge. Based on this ruling, the court had to respect the meaning of the word must, thus prompting an appeal to the CCJ. So one of the issues to be determined by the CCJ was whether the law had in fact been afforded immunity from judicial challenge. In other words, was the law saved from judicial challenge? Section 26 of the Constitution, the Barbados Constitution, states in part as follows: nothing contained in or done under the authority of any written law shall be held to be inconsistent with or in contravention of any provision of sections 12 to 23. So here are some excerpts from some of the reasoning of the CCJ. Mandatory penalties deprive the court of an opportunity to exercise the quintessentially judicial function of tailoring the punishment to fit the crime. The general savings clause is an unacceptable diminution of the freedom of newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. It is incongruous that the same Constitution which guarantees that every person in Barbados is entitled to certain fundamental rights and freedoms would deprive them in perpetuity from the benefit of those rights purely because the deprivation had existed prior to the adoption of the Constitution. And note if you see words in bold from excerpts from the reasoning, really that's my emphasis. With these general savings clauses, colonial laws and punishments are caught in a time warp, continuing to exist in their primeval form, immune to the evolving understandings and effects of applicable fundamental rights. This cannot be the meaning to be ascribed to that provision, as it would forever frustrate the basic underlying principles that the Constitution is a supreme law and that the judiciary is independent. Note the reference to evolving understanding of fundamental rights. Note the language forever frustrate. Isn't it the case that the legislature could have amended the laws? So basically the CCJ said, listen, we now have a new understanding of human rights. The savings law, the savings clause is depriving Barbadians of these rights according to a new understanding. So the law regarding mandatory capital punishment cannot be declared constitutional. As the law was declared unconstitutional, and so the appeals were allowed. Note the language used by the CCJ, not unique to them. I've seen that type of language in the Privy Council. Judges tend to wax lyrical when it comes to the matter of rights. Here's an interesting commentary on this case by one of the CCJ judges himself. Jamadar JCCJ, judge of the Caribbean Court of Appeal, provided the answer. So let me just backtrack. So how is the Nervais-Severin decision to be interpreted? Jamadar JCCJ provided the answer in an address given at the Belize Annual Law Conference 2022 on the 14th of January that year. He spoke of the decision in the case of BISL versus AG of Belize and said then concerning the decision in Nervais, in effect, the decision in Nervais and Severin is monumental in Caribbean jurisprudence because it establishes that even the literal text of a constitution is not infallible and is at once subject to certain basic underlying principles. What becomes normative and authoritative is ultimately not the letter of the text, note that, but the basic deep structure, certain non-derogable features, principles, and values that underpins, informs, and constitutes the text as a constitution. This is clear because in Nervais and Severin, the general savings clause that was whittled away and considered subordinate to the unwritten and or preambular value of the rule of law was a part of the Constitution itself. Thus, even though the Constitution, as explicitly avowed supreme law, contained a general savings clause, that specific clause was deemed subject to this basic underlying principle of the rule of law, which was ultimately considered to be the more supreme constitutional principle. I move now to the McEwen judgment, the cross-dressing case. So in June 2018, a day after the Nervais judgment was issued, the CCJ heard the case of McEwen versus AG from Ghana. The issue involved the legality of a law which prevented cross-dressing. And from the case, we learned that the material part of Section 153 makes it a crime for a man to dress in female attire or for a woman to dress in male attire in a public place for an improper purpose. This was what Honorable Justice Saunders had to say, and Mr. Justice Saunders is now the president. This is what he had to say by way of preliminary remarks. Difference is as natural as breathing. Infinite varieties exist of everything under the sun. Civilized society has a duty to accommodate suitably differences among human beings. Only in this manner can we give due respect to everyone's humanity. No one should have his or her dignity trampled on or human rights denied merely on account of a difference, especially one that poses no threat to public safety or public order. It is these simple verities on which this case is premised. The first and fourth named appellants are or are perceived to be different. They are transgendered persons. Their sense of personal identity and gender does not correspond with their birth sex. As a result, their appearance, mannerisms, and other outward characteristics are not consistent with society's expectations of gender normative behavior. That is their reality. It is a reality that is different from the one experienced by most persons. Unfortunately, it is a reality that, for whatever reason, confuses many and frightens, even disgusts some in Caribbean societies, often leading to derision of and sometimes violence against those who are different. It is for courts to afford the protection of the law to those who experience the brunt of such behavior. Until this court's recent decision in Nervais, remember we just dealt with Nervais, it has been the conventional wisdom that the Savings Clause completely immunized pre-independence laws from being held to be in contravention of the human rights laid out in the Constitution. By shielding pre-independence laws, because there were laws in existence at the time of independence from judicial scrutiny, savings clauses pose severe challenges. Note, savings clauses pose severe challenges both for courts and for constitutionalism. Law and society are dynamic, not static. Constitution must be read as a whole. Courts should be astute to avoid hindrances that would deter them from interpreting the Constitution in a manner faithful to its essence and its underlying spirit. So he came up with 4 principles, or he enunciated 4 principles. Firstly, the Savings Clause must be construed narrowly, that is to say, restrictively. Secondly, only challenges to the stipulated human rights provisions are barred. Thirdly, courts should, as far as possible, avoid an interpretation of domestic law that places a state in breach of its international obligations. And fourthly, and this is the one now which is the sticking point, Jamila will assist us in knowing how the Privy Council interpreted this one, or what they had to say about this one. Courts should first apply the modification clause to the relevant pre-independence law before attempting to apply the savings law clause. So basically he was saying this, modify first before attempting to apply the savings law clause. Excerpts from Anderson, judge of the Caribbean Court of Justice, and he's the next incoming president, I believe. Cross-dressing is an entirely innocuous act in that it does not invade the physical or proprietary interests of another. For that matter, it does not involve self-infliction of harms to one's own body or damage to one's own property, areas in which some have argued that the society might have an interest to protect. Nor does the act involve deception of any kind. Again, that emphasis is mine. Excerpts from Barrow, JCCJ. He spoke of Victorian values. In interpreting this criminalization of cross-dressing, it is necessary to consider the social and moral values that operated at that time in England and the colonies, including British Guiana, during the reign of Queen Victoria. Those were the values that led to the passing of this type of legislation in the metropolis and in Guyana. The Victorian fervor to suppress homosexuality is well documented, and it was against related conduct that the section was directed. The cross-dressing proscription, along with many other provisions in the Act, such as declaring a man to be a vagabond and subject to a fine because he does not work and support himself or his wife when capable of so doing, is a law that belonged to a different time. It criminalized the expression of sexual orientation and gender identification at a time when state intrusion of that nature was the norm and human rights were at best a developing intellectual concept. The court's decision in Nervais and Severin, delivered just 1 day before the instant appeal was argued, has now definitively established that the savings law provision in the Constitution of Barbados does not make existing laws immune from declaration of invalidity for inconsistency with the Constitution. Note well. This determination is equally applicable to the laws and Constitution of Guyana, and therefore Section 153L is no longer to be regarded as saved from being declared inconsistent with the Constitution. So not surprisingly, the cross-dressing law was declared unconstitutional. So note what he said. Same thing that we dealt with in, same principle that we applied in Barbados, we're going to apply in Guyana. What do you think would happen for appeals that come from Jamaica to the CCJ? There's some other comments which I find to be most concerning. The Honorable Mr. Justice Adrian Saunders, while president of the CCJ, while addressing a local audience of judges and other dignitaries, stated that, and I quote, "In a healthy democracy, a decent percentage of the judgments of the Court of Appeal, perhaps about 10 to 15%, should be appealed to the apex court so that the court can interstitially and in partnership with the legislature close the gap between law and society." So I ask two questions. Was the president saying that judges in partnership with the legislature have a responsibility to close the gap between law and society? Who gave judges that responsibility? Well, some of us thought the responsibility of judges was to adjudicate and apply the law. It is therefore not surprising that they arrive at their decisions in both Nervais and McEwen. Our Charter of Rights, as I said before, contain a number of saving clauses, including clauses to save marriage, to save the burglary law, to save the life of the unborn child. Considering the judgments of the CCJ, especially the monumental decision in Nervais and the opinions which they have expressed extrajudicially, I'm of the view that the savings clauses in our Charter of Rights is not safe in their hands. Now, just to say that the JCPC has similar language about rights, but the how they have dealt with item 4 of Justice Saunders' formulation has made a big difference. And I end by saying, it certainly would be a twist of irony if the CCJ, via its judgments, activates shifts in the moral and legal environment of the Caribbean to reflect the morals of our past colonial masters from whom we are trying so hard and desperately to escape. And that is the end of what I have to say. I thank you so much, Madam Moderator, and I turn back over to you. Thank you so much.
Thank you very much, Ms. Richards. That is indeed a very interesting presentation, and that's not the last of what you have to say, because I'm sure there will be questions. Over now to you, Jamila.
Okay, good morning, everyone. All right, so my task today, let me just quickly share my screen. My task today really is to look at the Privy Council and its approach to the saving law clause. Before I get into that, I just want to say something briefly. So we have already had a definition of what the saving law clause is, but why do we need a saving law clause? So a saving law clause has always been present in our Constitution. When our Constitution was passed in 1962, we had what was called a general savings law clause and a specific. The general savings law clause would have saved all laws that existed prior to the Constitution. When we passed our Charter of Rights, which has replaced Chapter 3 of our Constitution, 1962 Constitution, this is the chapter that contains fundamental rights. Parliament thought it necessary not to have a general savings clause that would save all laws, but rather to have specific savings law clauses that would save specific laws or punishment authorized under our law. But why do we need this? So human rights have been interpreted in a certain way in other countries and purportedly in international law. It is a debate as to whether or not what certain persons would say amounts to human rights under international law actually does. But there's an interpretation of human rights in other countries. And the concern is that our courts, in interpreting our rights, may look at how these countries or how international law bodies have interpreted these rights. And the concern is that they may interpret these rights in such a way that we as Jamaicans do not agree with. And so when our parliament was passing the Charter of Rights, it decided that there were certain laws that they wanted to make sure were not interpreted in such a way as to be regarded as to being in breach of certain human rights. And that is why we have certain saving law clauses in our Constitution. And so Mrs. Richards has already gone through the list of them. As she indicated, I think I have identified about 4 saving law clauses in our Constitution. We have one that deals with preserving punishment, which was lawful prior to the Constitution. And then we have the saving law clause that deals with saving certain laws or actions that exist for the purpose of a period of public emergency or public disaster. Of course, we have the one that is currently being challenged in our courts that deals with sexual offenses and the life of the unborn and obscene publication. And then we have the one that deals with marriage. And we have defined marriage in our Constitution, and we have also included a saving law clause which would ensure that the interpretation of marriage definition is restricted to one man and one woman. So that is why we have these saving law clauses. They're not just there just to be there. So the Privy Council is the final appellate court for Jamaica and other Commonwealth countries who have retained that court as their final appellate court. Now, what has the Privy Council had to say about savings law clause? So prior to the passing of our Charter of Rights, the Privy Council has had to consider the saving law clause that we had that was passed in our Constitution in 1962, and also the saving law clauses that other Caribbean countries have in their constitution when they became independent. Now, essentially, the principle is that once the law is an existing law, and this is important, when we say an existing law, we mean a law that was in effect at the time that the saving law clause came into being. I have to say it came into being because we now have a saving law clause which did not come into being when our Constitution was passed in 1962, but these saving law clause now exist as a result of the amendment to our Constitution by virtue of the Charter of Rights, which was passed in 2011. So once the law is an existing law covered by the saving law clause, it cannot be regarded as being inconsistent with any of the fundamental rights set out in the Constitution. And it has to be an existing law, meaning that if the law is amended since the saving law clause has taken effect, it no longer has the protection of the saving law clause. Now, so it was well settled by the Privy Council years ago that the saving law clause must be given effect to all existing laws. But recently, in the case of J. Chandler, the Privy Council reviewed the principles governing the interpretation and application of a saving law clause. And why did they do this if the principles were already settled? Well, they did this because of the 2 CCJ cases that Mrs. Richards went through a while ago. There was a case in Trinidad and Tobago, J. Chandler against the state. Now, this person had been convicted and was given the penalty of the mandatory death penalty. And he appealed, of course, the ruling of the court, but he was unsuccessful. What he did now was he sought to challenge the constitutionality of the mandatory death penalty as a result of the decisions that Mrs. Richards just looked at that came from the CCJ. The argument was that in light of these decisions and the interpretation of the CCJ of the saving law clauses, the Privy Council was being asked to reconsider the principles that it had applied as it relates to the saving law clause. And so the Privy Council considered the two CCJ cases of Nervice and the Queen and McCowan and the Attorney General of Guyana. Now, in doing that, of course, the Privy Council went through the previous decisions it had made in relation to the saving law clause. And one of these decisions is the case of Boyce against the Queen. That was a case from Barbados, interestingly, which looked at the very same issue that the CCJ looked at in the case of Nervice and the Queen. It was exactly the same issue, whether or not the mandatory death penalty in Barbados for the offense of murder was constitutional. The Privy Council had ruled in the Boyce and Queen case that it was saved because it was an existing law. And so because you had a saving law clause, which said that existing law was it was protected from being inconsistent with or in contravention of any of the provisions of section 12 to 23, which would include the right not to be subjected to torture or to inhumane or degrading punishment or other treatment. So because the saving law clause protected that law, the Privy Council in Boyce and the Queen said that the mandatory death penalty was constitutional. This is, of course, to be contrasted with the decision that Mrs. Richard just went through, where the CCJ found that it was not. And this was what the court had to say in the Privy Council in Boyce and the Queen. The language and purpose of Section 26 are so clear that whatever may be their lordship's view about the morality or efficacy of the death penalty, they are bound as a court of law to give effect to it. And this is a very important statement being made, because this is what the judges are saying. They're saying that, look, it is not our views that matter. It is the views of the people of Barbados who elected persons who passed certain laws and implemented a saving law clause. And so the court felt that having done that, the Parliament of Barbados having done that, they were bound as a court of law to give effect to it. Of course, the CCJ had no such belief. The court also pointed out that it is accepted that it is simply not successible to a construction, however enlightened or forward-looking, which would enable one to say that Section 26 was merely a transitional provision which somehow and at some point in time had become spent. And that Section 26 would have been the saving law clause in the Barbados Constitution. It stands there, and that it, of course, is the saving law clause, protecting the validity of existing laws until such time as Parliament, not the courts, Parliament decides to change them. And their lordship in so holding also rejected the argument that a provision in the Barbados Order in Council, which did not form part of the Constitution, but merely brought the Constitution into effect, could require the existing law so far as possible to be modified to conform with the relevant legislation. This was something that was examined as well in the Nervice case from Barbados that the CCJ looked at, because one of the arguments being made that in addition to the saving law clause not being applicable, the argument that was being made was that the Barbados Order in Council contained a provision that allowed you to modify a law that was not in conformity with the Constitution. And the argument was that since the mandatory death penalty was not in conformity with the fundamental right, then you could use the Order in Council to modify it irrespective of the presence of the savings law clause. This argument was rejected by the Privy Council in the Boyce case. The second case that the Privy Council also reviewed in the Chandler case was the case of Matthew against the state of Trinidad and Tobago. And this case was a case from Trinidad and Tobago, which once more considered the constitutionality of the mandatory death penalty in Trinidad and Tobago. And they were considering whether or not it was constitutional based on Section 4, which declared the right to life, and Section 5, which protected against cruel or unusual treatment or punishment. Now, the Constitution of Trinidad and Tobago had contained a saving law clause which prevented an existing law from being inconsistent with those sections of the Constitution. So the Privy Council applied the principles it set out in the Boyce case and said that the law enacting the mandatory death penalty was an existing law when the Constitution came into force, and so the saving law clause prevented it from being invalidated by the sections dealing with right to life or cruel or unusual treatment or punishment. The Privy Council then in Chandler went on to look at the CCJ cases and what those cases said. I will not go through that since Mrs. Richards has already done that. So the CCJ, the Privy Council in the Chandler case then went on to say what it considered to be the law, having regard to what it set out in Boyce and Matthew, and having regard to what the CCJ applied in the two cases. So the Privy Council, having reviewed the CCJ's decisions in Rice and McQueen, rejected the findings of the CCJ so far as they relate to the application of a savings law clause to existing law and its construction in light of the modification clause to be found in the statute which brings the Constitution into effect. The Privy Council instead declined to depart from its judgments in Matthew and Boyce and reiterated the principles in those cases. And His Lordship, Lord Hodge, summarized essentially what those principles were. But before doing this, this is what he had to say at paragraph 22 of the judgment. As the text of a constitution is a living instrument, judges in performing that task may have to re-examine periodically the application of the provisions of a constitution to contemporary life. But not all provisions in our Constitution allow themselves to be adapted to changing attitudes and changes in society as the broadly worded statements of fundamental rights do. Some provisions are concrete and specific, and a savings clause that protects existing law is one such provision. He then went on to summarize the principles. So the argument was in the Matthew case, as I'd indicated, was that what one could do is modify the law to bring it to make it consistent with the rights provision. And in doing that, you would then need not to trouble the saving law clause. But the court said no. You cannot use a legislation which is not a part of the Constitution to modify a law when the Constitution itself says that that law is immune from challenge. And he made the point that the saving law clause, which is contained in the 1976 Constitution, and we bring this to Jamaica now, so our saving law clause now is contained in the Charter of Rights, is not a transitional provision. It makes existing laws conform with the Constitution by disapplying Section 4 and 5. To put this in a Jamaican context, what this means is that the saving law clause essentially expresses the will of Parliament that the laws that it relates to are consistent with the fundamental rights set out in the Charter of Rights. And he made the point that in 1976, because Trinidad, like us, amended their constitution, they did it in 1976, we did it in 2011, he made the point that Trinidad decided to keep the saving law clause. And likewise, we have decided to keep certain specific saving law clauses in our constitution. The living instrument doctrine enables broadly worded statements of fundamental rights to be adapted to reflecting changing attitudes and changing society. But not all provisions in our Constitution are of that nature. The meaning and purpose of the Saving Law Clause, which preserves existing law, does not change over time. So the Privy Council has reiterated that the Saving Law Clause does not change over time. The Saving Law Clause, once it deals with an existing law that is covered by the Saving Law Clause, one cannot challenge that law on the basis that it breaches a fundamental right. This is, of course, contrasted to, the CCJ's blatant contempt and disregard for the Savings Law Clause. What is interesting as well is that as recently as 2023, the Privy Council looked at another case from Trinidad and Tobago, the case of AG against Maharaj, and applied the principles it had reiterated in the Chandler case to a question of whether the Sedition Act of 1920, which was a pre-independence law, is consistent with the 1976 Constitution of the Republic of Trinidad and Tobago. Because the argument was being made again, once more, as was made in the CCJ, that the Saving Law Clause should not be given effect, and also that the law could be, you could use the modification provisions in the ordinance to bring the law in conformity with the rights. But the Privy Council once more maintained what it had said in the Chandler case. Now, the principles reiterated in the Chandler and Maharaj are the principles applicable in this jurisdiction, because so the Privy Council is our final appellate court, but of course it's the final appellate court for other countries. And of course, the cases that I just looked at were not cases that came from Jamaica that the Privy Council considered, but there were cases from Barbados and Trinidad. But the principles set out in these cases are applicable to this jurisdiction, Jamaica, and our lower courts are bound to follow the principles in considering the applicability of the various Saving Law clauses in our Charter of Rights. Why is this? Because these principles were applied by the Privy Council in the Jamaican case of Lambert, Watson, and the Queen. Now, the Lambert-Watson case was a case once more where the Privy Council was considering the mandatory death sentence, and in considering whether or not it was constitutional, the Privy Council applied the principles that they had previously set out in the Boyce and in the Matthew case. The difference with the Lambert-Watson case is that there had been an amendment to our law since the Saving Law Clause had been passed, and so the Saving Law Clause would not have protected that law. And so that is why in Lambert-Watson, the Privy Council found that the law was unconstitutional, not because they did away with the Saving Law Clause, but because the law was not protected by the Saving Law Clause, because it was not the law that existed at the time that the Saving Law Clause came into effect. And so we are bound by what the Privy Council has set out in those cases. The question is, if it is that the Jamaica decides to do away with the Privy Council and have the CCJ as its final appellate court, it is very clear that the CCJ will not be applying the principles set out by the Privy Council, but will be applying the principles that it has set out in the case of Nervias and McEwen. I just want to read a part of a quote from the Lambert-Watson case, because you see how the Privy Council has approached its task in construing the Saving Law Clause. And this is what the Privy Council said. The board's task has been to construe the Supreme Law Clauses and the existing law clauses as it finds them, and then to apply them to the facts. In their largest opinion, the language with these provisions have used is plain and unambiguous. And they had this to say as well. Their lordships firmly believe that respect for the rule of law requires them to give effect to Section 26(8), that would have been our Saving Law Clause at the time, of the Constitution of Jamaica, not to ignore it. When it says that existing laws are not to be held to be inconsistent with any of the provisions of Chapter 3, Given effect to this instruction, they find that existing laws are in conformity with that chapter. There is nothing in them which requires to be adapted or modified to bring this about. One of the arguments that was made also in the Nervice and McQueen case was that you could use the separation of powers to say that the saving law clause was not applicable. But the court in Chandler made the point that the separation of powers principle is not a principle in and of itself. It's a principle to be found in the Constitution. And Parliament can, in its own right, set out which body of government is has the authority to do certain things. And that is why it rejected the argument in terms of separation of powers. So in conclusion, the Privy Council has shown as recently as 2023 that it is prepared to give effect to a saving law clause in our Constitution. Once established that the law being scrutinized is a law which was enforced prior to the coming into effect of the Constitution, and in our case, the Charter of Rights. This is to be contrasted with the CCJ, which has expressly expressed clear contempt for the saving law clause and has refused to apply it. I thank you for listening.
And I thank you for your presentation, Jamila. It's very thought-provoking. It was packed with a lot of jurisprudence, a lot of case law, which will take, I think, some thinking through for persons and many persons in this meeting, the process. I'm not certain how many lawyers we have. I recognized some names as they came in. And I suspect also that we have, I don't want to use the word ordinary. By that I mean persons who are non-lawyers, just persons wanting to understand. I think access to the presentations would be useful. And so I'm hoping, pardon me, that the JCHS, the Issachar Foundation, will make your presentations available and that you will agree to the Word and the PowerPoint presentation that Ms. Richards used earlier to make them available to those who are here listening. So that I just want to reiterate that your questions, please, for those of us in attendance, kindly post your questions in the chat. You will remain muted for the meeting, but if you have a question, please post the question in the chat and we'll be happy to pose them to the presenters. Very, very good presentation. I learned so much and I've been involved in the Tomlinson case. I'm going to pose the first question to Jamila because you didn't say too much about the Tomlinson case and I just wanted your thoughts on what Justice Batts had to say in particular about the savings law clause.
Well, to be very frank with you, I was a little bit disappointed in the judgment that was given by the full court in the Tomlinson case, because I don't think that it could have been a little bit more in depth. But essentially, I got the feeling or the understanding from what the judges said in their separate judgments, especially Justice Batts, that they really one, they thought it was very clear that the law that was being challenged was in breach of fundamental rights. You know, they just quickly went to what other countries had interpreted the rights as being and international law, rather than, you know, looking at it themselves and analyzing things. And so, you know, Justice Batts, I will tell you this, if there was no savings law clause, we certainly would have had that law struck down by the full court.
Yes. And of course, if there was no Privy Council, the judgments of the CCJ would have been more persuasive in the Jamaican context.
Indeed, it's interesting. I honestly believe that if the Privy Council had not already given decisions on this matter by which we are bound, I believe that our full court would have applied the judgments of the CCJ in considering whether or not the saving law clause was applicable. And I do believe that they might have very well have been persuaded by the CCJ decisions not to have regard to the saving law clause. But of course, they were bound by the Privy Council decisions.
Thank you. I see a question in the chat, but I want to put something to Ms. Richards, because perhaps, am I seeing Ms. Richards? I'm seeing Jamila. Yes, there you are. So the cases that you both have been discussing this morning, they've dealt with those that have come before the CCJ and the Privy Council. They've had to do with murder, they've had to do with cross-dressing, sedition, and so on and so forth. It seems that quite apart from the nature of the case, what fundamentally could be happening when you look at what the CCJ's approach has been is a possible, on some views, a usurpation of the power of Parliament. Yes? And so I'd like you to comment on that, Ms. Richards, if you would.
Thank you, Madam Moderator. I certainly think that that is part of the dilemma we face with the CCJ, in that they see themselves as having a role akin to that of legislators, see themselves as having a role in restructuring society, re-engineering society. And of course, the passion was to free us of colonial laws, maybe colonial ties. So I see in the CCJ, by their judgments and their comments out of court, I see in them an approach to justice which does not, or an approach to giving judgments in matters which does not only apply, which is not only the adjudication of the issues, but also taking into account where they believe society ought to go. And this is a big part of the problem. Is that a part of the role of judges? And some of us say no.
Yes.
Could I just comment on that, Helene, before you go further?
Yes, please go ahead.
Yes, it's interesting. I will read from you a quote from the AG and Maharaj case that the Privy Council looked at in 2023. It says, if the savings clause in Section 6 could too easily be circumvented by resort to Section 1, that itself would be inconsistent with the democratic principles on which the Constitution is based. This is because it would remove a certain subject matter from the province of the elected legislator and place it within the province of the unelected courts. In the board's view, one of the functions of Section 6, as the saving law clause of the Constitution, is to give Parliament the power to determine which pre-independence law should be retained and which should not. I think that's
good quote.
That's very enlightening.
Thank you.
Very enlightening. And at some other point, perhaps there can be another meeting to discuss similar tendencies in other judicial bodies, such as the OAS. That's a challenge I'm throwing out to both of you. So I don't want to ignore the question, and I saw a hand going up, and I'm just reiterating the fact. Please post your questions in the chat. I want to encourage persons who are in attendance, who are not attorneys, to post your question in the chat, regardless of how non-legal your question may sound. Because if you leave here today as a non-lawyer, scratching your head about the law, we would not have helped you or assisted your understanding in the way we would like to. So please, no matter how simple you think your question is, post the question in the chat. I must ask, this is a follow-up. So if there is a possibility of a usurpation of the power of Parliament, why is it that Parliament has remained silent in Barbados and elsewhere?
That is an excellent question. And it's one of the things we pointed out when we made a presentation on Charter of Rights in 2000, 2008, I think it was, that with countries that accept broad Charter of Rights, it results in a limitation on the powers of Parliament. Basically, in these countries, Parliament has ceded their authority to legislate has almost ceded authority to legislate to the judiciary. And, something we pointed out, so that is a very, very interesting question, which possibly only the Parliament itself could answer, Madam Moderator.
Yes, and as I go to the questions in the chat, I'm suggesting that Parliament has found it convenient where it has occurred. Parliament has found it convenient to allow it to happen because it relieves them of the political pressure to be accountable to the democratic principle and the people who have elected them to sit in the Parliament.
You have it. That's it.
So the first question that I'm looking at in the chat is, what are the sneaky ways? I like the way you put it. You said, I can put it properly, but I like the way you've put it. What are the sneaky ways that our savings law can be subverted? I think about the backdoor question of modifying the laws so that people would not have been aware of the impact of the savings law clause and the change that would have occurred. Could you speak to that? I'm going to ask Jamila.
Okay, so as Mrs. Richards had pointed out, one of the arguments in the CCJ cases, and those arguments are not new because those arguments the Privy Council considered in the previous cases of Boyce and Matthew, was that there was there's a provision in the order of council. So the law that would have brought the Constitution into effect would contain a provision that would say that all laws that were not in conformity to the Constitution should be modified and adapted to make them in conformity with it. And the argument was that, well, you should use that law to modify any law that the court regards as being in breach of the fundamental rights without having to so you could do that, and as the person put, sneakily, not have to have regard to the saving law clause. But what the Privy Council made very clear is that, look, the saving law clause is contained in the Constitution. And if the saving law clause is contained in the Constitution and it says that these laws are not to be found to be inconsistent with fundamental rights, how can you have a law which is not in the Constitution, which says that you can modify laws to bring it into conformity to the Constitution? How can you say that that law must apply above the saving law clause, which is in the Constitution, which is the supreme law of the land? So you see, the argument that these laws are in breach of the fundamental rights, I like to put it this way. The law that the saving law clause protects can never be in breach of any fundamental rights, because this is what the saving law clause is saying. It is saying that that law is consistent. So if we may have other countries and other jurisdictions that have interpreted that very same law to be in breach of that same fundamental right, but in our jurisdiction, we have said that it is not. That is the point of the saving law clause. So that is one way that they sought to do that in the cases that the CCJ considered, and they were successful. But the Privy Council has once more said, no, you cannot use that method because the saving law clause is a part of the Constitution.
Thank you. From Sarah, what can we do to ensure the CCJ does not become our final court of appeal, since they obviously oppose godly values? Anyone can take that.
Well, that's almost a political question, we need to hear. That's a political question. So maybe what ought to happen is that there should be a referendum on the final court. Maybe that's one way around it, to have a separate question posed in any referendum. Which court do you want? The problem is that some people have access to the media, and it's a very politically charged issue. because we're trying to get rid of the monarchy. So we are tying the monarchy to the getting rid of the monarchy to the whole matter of getting rid of the Privy Council. And one can see one can see the political argument. You want to get rid of any external input within your society. We don't want to go to the, pardon me, we don't want to go to the white man for justice. We can administer justice ourselves, and one can see that. But the issue, part of what we have to consider is this. It's not just a matter of white or black. It's the approach of the courts, of the two courts, to the laws which they will have to adjudicate. Which court is going to respect our laws? So it all depends on how are we, and to try to get back to the original question, how are we going to have a say as to which court is our final court of appeal? We need to hear specifically from the two major political parties. I think one has made it clear what they want. The other it's not so clear. We need to hear clearly the positions of both political parties. And maybe, I think we should give the people a chance to vote. But of course, it's getting the information out that all is not as it appears with the CCJ will be difficult.
Thank you. So that my agenda tells me that the meeting was to have ended, or is to end at 11:10. We've had a flurry of questions coming in. And so I'll be advised by Issachar how far we can go. But I would want to start with Maurice and Graciela. It seems it's more of a statement. It seems that the approach being taken by the CCJ in relation to the Savings Law Clause and the application of newly constructed rights, real or fake, makes nonsense of what the majority may think and nonsense of what they think democracy is. What then is the point of voting for a position? I think that may be a rhetorical question, and I will leave it. It's a good question for us all to ponder. What then is the point of voting? And it seems the approach being taken by the CCJ, let me see, what I'd like to know, this is coming from Dennis Casanova. What I'd like to know is, how exposed are we right now to legislation that will allow for same-sex marriage? Is the current stride of government aiding this? And how can we go about stopping going to the CCJ? So is same-sex marriage something that is looming on the horizon? Is our government trying to sneakily get us there?
Jamila?
Well, I mean, we have defined marriage in our constitution. So that would have to be amended.
And so the answer is, we're not anywhere near there.
But what we do know is what is happening within the boardrooms, what is happening with the different grants and funding being made available. Are there any, undisclosed conditions? That's what we don't know, what's happening in secret behind closed doors. But thankfully, the law is there.
Yes, and so what are the implications of what is happening behind closed doors for same-sex marriage? Join it up for us.
What could happen? So it could sneak into our society. For example, within our educational system, HFLE, for example, so it could be brought in different ways. Equality legislation, maybe, non-discrimination legislation. So maybe not a direct attack, but indirect attack and over the time, stealthily over time, you change the mindsets of individuals. At the university and at our tertiary institutions, there was a whole matter of using pronouns. Pronouns. I remember at the UWI, there was that issue. So the approach I think which is being taken by the activists is to attack sideways, not directly. Change the hearts and minds of people by changing the minds of our young people, both at the high school, primary, and also at the tertiary level. So that is the approach which is being taken, not a direct approach, at least not yet. And so that is what we have to look out for.
The re-engineering of our society, the re-socialization of our children in particular. From Cedric Moss, what's the status of the Tomlinson case? Was it appealed to the Privy Council?
Jamila.
So it has been appealed to our Court of Appeal, because you have the Supreme Court. Any appeal from a decision of the Supreme Court would then go to our Court of Appeal. The Privy Council would be the next level. So there is an appeal pending in our Court of Appeal, and there is an application to be considered by the court in December of this year. The Attorney General has applied to have the appeal struck out, and that application is to be considered in December.
What are the issues in the appeal?
Well, there are several issues, but essentially, they would be saying that the full court erred in finding that the saving law clause was applicable.
Yes. Very well. What is AOS that Helene Cody mentioned? I did not mention any such thing. I mentioned the OAS. I'm taking liberties with you, Cheryl Boucher. It's the Organization of American States. And I know that Jamila Thomas follows developments there. And that is another rich bed to dig up, because what is happening with jurisprudence, what we're talking about here in terms of the developments at the CCJ and the pronouncements, I would venture to say pale in comparison to what some of the judges at the OAS have said in terms of interpreting human rights, and they've been doing it for decades now. Would you agree, Jamila?
Yes, not just the court, but the Inter-American Commission.
Mm-hmm. The commission and the court, yes.
More so the commission, I would say, and the court as well, but the commission certainly.
Mm-hmm. What question for Jamila? Was the death penalty ever carried out in the case in Trinidad?
Which case? The last one?
They did not specify.
The Chandler case? No. In fact, before, well, the last case that they considered death penalty, that would have been the Chandler case in 2022. Even before the Privy Council considered that appeal as to whether or not the death penalty was constitutional, that person's sentence had already been commuted to a life sentence.
Oh, I see. So let's see, non-lawyer here, Robinson. I wish I could hear from more lawyers, although the time is gone. What are the checks and balances, if any, that guide judges to refrain from re-engineering society by opinions, interpretation, rather than adjudication? Either panelist can answer.
I posed that very same question, maybe slightly different wording, to an eminent jurist a couple weeks ago. And I did not get a definitive answer. And so that's why it's important who your final court is, or which court is the final court, because if one can appeal from one level to the next, but there comes an end to appeals, so it's very, very important as to who or which court is in fact the final court, because a higher court can correct excesses, but the final court has the final answer.
Up to recently,
That's
though,
all I can
you
say.
would have up to recently one as a legal practitioner going through law school, you would have heard so much about this. Not sure if I'm pronouncing it right. Stare decisis principle, and you would have thought that that principle would have been the plumb line, that judges would have been beholden to that, and it would have determined in the same way as you had said earlier, you'd be able to look at the cases and be able to predict the outcome. But with the CCJ, it's become difficult. And
You know, I had in mind some time ago a lecture called With a Stare Decisis. You know.
yes, with a stare decisis, Jamila.
Oh, well, you see, the thing is, the thing about the CCJ is that
But
it's
what
a
is
new
it first of all? What is it first of all? Stare
Oh, I'm
decisis.
sorry. That is
Oh, Jamila has frozen. Looks like a connectivity issue.
where a court has already made a previous decision. Hello?
Yes, we're not seeing you, but we're hearing you.
Okay, I turned off my video because right. No, I'm saying that that is essentially the principle where the court is to follow previous decisions that have been made in respect of a similar matter made by a higher court. Essentially, that is it. But you see, the thing about the CCJ is that it was relatively speaking a new court. So there are no, in terms of the decisions that it has made, there are none really to follow in relation to this issue. And it did not feel that it was bound to follow the Privy Council, which it is not, because it is not under the hierarchy of the Privy Council.
I'm a little stumped and I don't want to continue because if you and I should engage, Shamila, there'd be no time. Stumped because what you've said raises so many other things coming up, but I'm going to go to the chat. And Doreen is asking, is there any evidence that the CCJ is particularly opposed to the laws that reflect the Judeo-Christian worldview?
Okay, so I have read, well, I gave some excerpts from the judgment, particularly in the McEwen case. There is also another lecture which Justice Saunders, another delivery which Justice Saunders himself made, and that dealt a whole lot with the whole issue of homosexuality. He spoke about 10 to 15% of our population being that way and that type of thing. So that certainly concretized in my mind that maybe for him and others, for Justice Saunders and others, this whole matter of homosexuality is a non-issue for them. So from the judgments and from extrajudicial deliveries, I certainly have come to that conclusion.
Yes, thank you for that.
If I may, I don't think we're necessarily saying to everyone, that the Privy Council is a court that upholds Judeo-Christian values. The point that we're making is that they are prepared to uphold our law. And the CCJ is not.
Very good. Very good. Thank you.
Yes, thank you for that. And so we have been given permission to go down to 11:30, and we do have some other questions. Please say what HFLE is, as mentioned by Shirley, in terms of changing societal views.
Dear God. Oh my gracious. HFLE was a textbook in the high schools. Let's see, human HFLE. It stands for Health and Family Life Education. And that was a book which was still being used in the high schools to deal with health and family life education. And some years ago, we found a number of offensive issues within that book, that publication, and they have different levels. Thankfully, well, Minister Thwaites, Ronald Thwaites, was Minister of Education at the time, and he understood our concerns, and not just our concerns, but the concerns of parents. And so there was some modification to the books. But we realized that there are still some things there within those books which could be detrimental. So generally, the literature which is being provided to our children has to be carefully scrutinized. And we as JCHS or Issachar or Lawyers Christian Fellowship cannot do that task by ourselves. We need parents to be vigilant about what is being taught to children.
Dennis comes back to say, I'm still a little unclear on my question, re the CCJ. Do we as the Jamaican public have any say in whether we retain the Privy Council or go to the CCJ?
I think we need to make our voices heard.
Well, address the procedure. I think what Dennis may want us to address is, and I think Jamila mentioned, referendum or no, is that required? What's the position of the parties? I think you may have addressed it, but just restate it, please. So we're clear as to, because you hesitated to say one particular question, well, that is political. All of what we're talking, if I were to sum it up, is political. It is all political, you know? Judicial activism is a matter of politics. The question as to how Parliament responds is a matter of politics. So what are the parliamentarians saying? What have they laid out as the roadmap to get us to the CCJ?
Well, certainly the opposition has made it clear that if they get in, they will be they'll be accepting the CCJ as being the final court of appeal. They have said that clearly, and that has created an impasse between themselves and the government, especially where the Joint Select Committee meetings are concerned. So the opposition has said that clearly. We haven't heard from the government what exactly their stance is on the matter. I think what people need to do is to engage their parliamentarians and the candidates in the upcoming elections to find out what their stance is on the matter. We also need to make it a big item of agenda for the upcoming elections. So it depends on which government, it seems, which party, but we don't know where the government stands on the matter. And it's time that we hear them clearly as to where they stand on this matter. You know, it's going to depend on who has control of the parliament, because the parliament will decide which court becomes or which court is our final court of appeal.
Yes, I hope that's helpful, Dennis. Not a question, Angie saying, just an observation. This is the first presentation on the CCJ versus Privy Council. Read the changes to the Jamaican Constitution that has dealt with the law as it relates to the decision taken, and why or why not change to the CCJ. All other presentations have argued. Oh, it's a direct message to me. Let me move on. I wondered where that was going. Thank you. The price of freedom is eternal vigilance. The people of our democratic nations need to make it abundantly clear that they will not accept the judicial activism of the unelected CCJ. Going back to the OAS, there was actually a grouping of parliamentarians of the Western Hemisphere that came together for the same purpose, to ensure that the unelected Inter-American Court of Human Rights, part of the OAS system, did not have the same effect, change the laws in people's constitutions. HFLE is a curriculum. HFLE is taught in primary schools as well. from Open Bible, is it that the CCJ will be, as proven, less likely to respect the constitutions of the region? Is it?
Certainly, that's my position. That's what I've seen from the judgments and from their pronouncements. Yes.
And Dennis has said, very helpful.
Maybe in certain respects. I'm not saying totally, but in certain particular respects.
Yes. And so we are just a few minutes shy of 11:30. I think that this would be a convenient time for us to move to the next stage of the program. And so I would like just to thank Ms. Richards, to thank Ms. Thomas. I want your copies of your presentation. I'm an attorney, but in reading that, I'm sure, would learn so much more. I think I speak on behalf of all the attendees here who are likely to have an interest in gaining access. So as I thank you and commend you both on your presentations, I turn you back over now to Dr. West for his wrap-up.
Thank you. Thank you for having us.
Well, let me thank everyone for excellent presentation and very good moderating. Let me just state my position up front so that there are no illusions. I think there are two important considerations when you are selecting your final court of appeal. And I think the people must select the final court of appeal. The first one is less important, but important, is what is the worldview of the court? And I think both the Privy Council and the Caribbean Court of Justice are what I would call post-Christian institutions. You know, in the past, God gave the law to Moses and Moses gave the law to the people. And the judges adjudicated on the law. They didn't seek to change or make law. We are in a totally new paradigm. Both the Privy Council and the judges of the Caribbean Court don't accept that law comes from God. They ignore design and purpose in the natural order of the universe in the consideration of rights. For them, rights depend on how people feel about it, and more importantly, how the powerful elite in the society feel about what they wish to do. So whatever people wish to do is a right. They both feel that way. The second and the more important consideration in choosing your final court of appeal is how do the judges see their role in coming to decisions? And it is clear that the CCJ gets a massively failing grade for that as far as I'm concerned, because the CCJ actually sees itself as a legislator, creating law, transforming the society, ignoring what is in the Constitution if it doesn't suit their ideology, and so forth. So even though I believe, even though Jamaica has, like, marriage is defined as between a man and a woman in the Jamaican Constitution, I think the way the CCJ sees itself is going to find a way to override that because it doesn't suit their ideology. I think that that is dangerous. We should not want that. I certainly don't want that. The Jamaican people and other people in the Caribbean should be aware of that. And I think they should reject it out of hand. I think it is delightful that Trinidad and Tobago has not accepted the Caribbean Court of Justice as its final court of appeal. And they got some excellent decisions coming out of the Privy Council. But it brings us to a third consideration in this new era of jurisprudence, where people have determined that man make laws, not God, is that final courts are correct, not because they are correct, but because they are final courts. And I think that we need to find, just as the Magna Carta was set up to bring the king down to earth, that he couldn't just tax people because it was his prerogative. I think that we are now at a point where we need to start looking at how we bring judges back to earth so that they adjudicate on the law that we, the people with our representatives, said, right, and rather than the laws that they think they should impose on society. So I would say that I think, thank you very much for your presentations. It's clear if we want to preserve what we think and not what the judges think, So we don't have a juristocracy. We need to stick with the Privy Council as it is at the moment. The problem with that is that the Privy Council could become like the Caribbean Court of Justice, and then what do we do? So this is why we have to start thinking of ways to bring them in line so that they do what we want rather than forcing us to do what they want. Just a reminder that we are scheduled to have look at other aspects of this issue. Another one is coming up in June, and we will let you know exactly when in June. Look out for the notices. If you have not yet become one of our regulars, please leave your email address or your contact so that we can get in touch with you to let you know when our next meetings are coming up. The other thing I just want to remind people is that the Issachar Foundation does have a YouTube channel, and this lecture will be posted on the YouTube channel as soon as we go through all the particulars, and that other lectures are on the YouTube channel. So please take a look and get yourself acquainted with the Issachar Foundation. We are here really, as we said, to let people understand the times so that they would know what to do. And that is what testifying to truth is all about. So in a very real way, we are testifying to truth. We want to thank you once again for being with us this morning, and we look forward to having you again in the future. Next one is scheduled for June, looking at a similar issue related to the law, and we look forward to having you. Thank you very much, and thanks to everybody who helped to make this possible.